to this meeting of the Planning Applications Committee. My name is Councillor Tom Bennett and I'm one of the Vice Chairs of the Planning Applications Committee, and I'll be chairing this evening's meeting. To my left are the other councillors, and it's the five of us who will be making the decisions this evening. I'll let them introduce themselves.
Councillor Arian Aratia Poland.
Councillor Wala Idris, Brompton and Hanscow.
Councillor Sam Macker for Queensgate.
Councillor Mohammed Bakhtiar Coleman.
And the other people sitting up at the table are the officer team who will be presenting the cases and advising us this evening. And the officer team is led this evening by Lisa Chun. The first item of business is apologies for absence. I don't believe we have any apologies. Second item is declarations of interest. So it's probably worth me declaring that myself and two of the other members of the committee went and visited one of the properties, which is the first case, 42 to 52 Earls Court Road, or rather the one of the objectors' properties that face that, with the planning officer, which is something we often do just to get a sort of on the ground perspective of the case, which was useful. And also declare that one of the objectors is known to some of the members of the committee, myself, Councillor Moretti and Councillor Mackover, and Councillor Idris, but no discussion of the case with that person, and we approach it with an open mind. Are there any other declarations of interest? Yeah, that's fine. No.
So when you said other councillors, you're referring to Councillor Mackover, Councillor Moretti and Councillor Idris.
Yes.
And you've all got open minds on these first two applications.
Yes.
Absolutely.
Yeah. Yep.
Okay.
Thank you. No other declarations of interest? No. We don't have any minutes to sign off, so I'll just run through the running order for this evening. So we start with the, well, first, before I do that, let me just quickly update people that two cases have been withdrawn from this evening's agenda. So 16 Drayton Gardens, which was both an application, planning application and a listed building consent application, were both withdrawn from the agenda last week. And yesterday, number 23 Camden Hill Square was withdrawn from the agenda as well. The remaining items on this evening's agenda, in the order that we will hear them, are 42 to 52 Earls Court Road, then the other application, 42 to 52 Earls Court Road, then 110 Camden Hill Road, then number 9 Colbeck Mews, and then number 12 Aubrey Road. So not particularly long agenda this evening, so hopefully everyone will be able to get home in good time. So those are the items of business. We therefore proceed to our first case, number 42 to 52 Earls Court Road.
Thank you, Chairman. So this application is the first of two applications that members will hear this evening at the committee. This first application relates to the erection of a gate at the rear boundary. So we will consider and I will present each application separately, and then we'll determine them separately as well. So the application site relates to number 42 to 52 Earls Court Road. It's a commercial building located to the west of Earls Court Road. It can be seen identified by the red arrow on this slide. So the application fronts onto Earls Court Road and then has a large rear extension to the back. To the back of the site are residential properties along Pemberton Place. And on this slide, which is the block plan, you can see that to the rear there is this alleyway or walkway to the rear of the site. The application, as I mentioned, relates to a gate, and this would be located on this element or elevation of the rear of the site here, where the arrow and my cursor is. So this application is retrospective, so the gate has been installed. So you've got the pre-existing and then the proposed elevation on the slide before you. And so you can see that previously it was marked by a part of a concrete wall, and then a timber fence on top of that wall. the proposal is to install this new timber gate, which we identified here. And then just in kind of photo form, so you've got the pre-existing, so it was there previously on the left-hand image, and then the proposed on the right-hand image. I believe that concludes my presentation. I would just draw members' attention to the addendum report, where there's an amendment to condition 1, just to add "and so maintained," as it is retrospective, and then also an additional recommended informative. Thank you.
Thank you very much. So we now go to comments from objectors and applicants. Registered to speak for objectors, I've got Benson Spears and Councillor Siren, both here this evening. Yeah. So the way it works is councillors always get 2 minutes to speak, and then other objectors get 3 minutes between them. In your case, all 3 minutes. Who would like to speak first? Thank you. Just give me 1 second. I'll get my stuff ready. Yeah, this is easy. Councillor Siren, would you like to? Shall I start? Oh, that's 1 second. 3 minutes whenever you're ready.
Thank you. There are certain inconsistencies in this application and the report which require certain clarifications. So according to the report, the decisive issues are preserving or enhancing the character of the area and appearance of the site and maintaining an acceptable relationship with nearby properties. Unfortunately, it fails on both counts. The appearance of a white brick wall is significantly different to a black door. And we have serious security concerns regarding the installation of this gate, as it does not maintain an acceptable relationship with our properties, as people have already been seen attempting to access the Trailfinders courtyard from the rear. Point 1.1 claims that the door replaced a previous timber structure. Unfortunately, this is also false. The boundary was marked by a brick wall and a timber fence, as confirmed in point 3.1. A brick wall which we have since begun to repair, following Alice Cobb's advice and approval, and at our own expense. This is the same brick wall which Trailfinders do not refer to in their application, instead referring to an 840mm height difference. Again, point 6.5 refers to a timber fencing and instead refers to a key difference of structure and form. This is inaccurate. The key difference is the structure and the access that it now provides. As such, describing this as a shared walkway is unfortunately misleading. This is a privately owned alleyway, owned and accessed only by the residents of Penrith Place. We appreciate the council's scope regarding access, building control and fire regulations, but we must stress that this was not, and it has never been, a pre-existing fire escape. It is categorically unsafe and unacceptable for such a purpose. And granting a door as a fire escape goes hand in hand with access and liability, and therefore ignoring such issues seems somewhat short-sighted. What happens if someone gets injured in the alleyway? Whose responsibility is it to maintain the alleyway? And will the residents be compensated for granting access? As councillors, you have the ability to prevent the ensuing mess that this will create. Point 6.9 and 6.10 confirmed that this application only serves the commercial property. No discussions were held between Trailfinders and the residents prior to the works. No consent was sought prior to demolishing a boundary wall. In fact, when this breach was first reported to the council, the Trailfinders property director claimed this was simply repair works which did not require planning permission. This is a corporate giant bullying its way onto our properties, and you are allowing it. Finally, comment 7 states that despite residents' objections to the false statements on the application, details are satisfactory to assess the application. We are curious to know how that can be possible when flagrant inaccuracies were included, such as claiming that the applicant is the sole owner of all the land to which the application relates on their certificate B, and also falsely claiming that no new public rights of way were needed nor need to be created. It is not just a door you would be approving, it would be a fire escape, and you would be exposing us to enormous liability should something happen. Therefore, should you grant this application, you would be setting a very dangerous precedent regarding gaining illegal access to private property, and we would demand that you provide a clear and detailed framework regarding the ensuing liability and responsibility of the applicant.
Thank you very much. Councillor Siren, you have up to 2 minutes whenever you're ready.
Thank you,
Mr. Chairman and members. I'm Anne Siren. I'm one of the Abingdon Ward councillors, and I wanted to speak about this application by Trailfinders, which has been made retrospectively. The applicant has knocked down a wall which doesn't belong to them and installed a door, presumably to provide a fire escape required due to the industrial level of plant that they've installed on their roof. And I do understand that applications can be made for land that doesn't belong to the applicant. However, our planning process does require applications to be honest and transparent. I mean, we are a local authority. And when people put in planning applications, they sign a statement saying that what they are submitting is true and honest. And that is not the case here. Apart from anything else, there is a wall in front of the door rebuilt by the owners of the land. To approve this application would make a mockery of our planning process, would be approving a door which can't be opened and a fire escape which in the event of a fire would be blocked by a solid wall. I urge you to refuse this planning application as another cynical attempt to use our planning system to impose unacceptable harm to our residents' living conditions.
Thank you very much. And are we joined by Claire Priest, the applicant, the agent for the applicant? It's okay, you can stay up because then we'll go to questions at the moment. So it's easier to have all of you here. It's Bruce, because the objectors have 5 minutes between them, you therefore also have up to 5 minutes to make any comments.
Okay, thank you. This application represents a minor amendment to the rear access to the property. It relates only to the replacement of an existing fence gate with a newer high quality gate. The previous fence was constructed of timber and painted orange. It was of poor quality and included a hinged ramp, which was not practical. The replacement is a far higher quality hinged gate constructed of painted timber. It is black and much more sophisticated in appearance. The fence can only be seen from the rear access path and the properties to the rear. As such, it has limited impact on the character and appearance of the conservation area or the street scene. The gate is required as a fire escape only, and the previous poor quality exit did not meet building regulations. The replacement of this gate is a very minor development. A drop-down fence already existed here, and therefore the new gate does not create a new access. It simply replaces it with a high quality hinged gate. It does little to change what residents to the rear can see either. In fact, it improves the visual amenity of this part of the property. There is no negative impact associated with the installation of this gate, as agreed in the officer's report. We therefore politely request the officer's recommendation to approve the application is accepted.
Thank you. Yes, no, please do.
That's more as well. No, thank you.
We now proceed to questions to objectors and applicants. Colleagues who would like to ask the first question, Councillor Idris.
Thank you, Chair. In your to the applicant, in your summation, you mentioned minor change. Could you explain to me the minor change?
Just to the gate is changing. The access is already so that as I understand it, the previous like a drawbridge, it dropped down, and that didn't meet building regulations for a fire escape. So it's just changing to.
And usually, when you have a fire escape, you have an assembly point. Where is the assembly point for this?
I'm just going to step in there very quickly because this is something that I think it's important we address and probably take it up with officers in a moment. As I understand it, we are not being asked to approve this as a fire escape. Whether they want to come back in the future and ask for it to have permission as a fire escape or whether to clear that with building regulations is another process. We are literally approving or not approving what's there, a door. We're not approving any particular usage of that door for a fire escape or for anything else.
Okay, my final question is for all three of you, is who owns the freehold of the alleyway?
The owners of the other properties. Yeah, it's on the casualties.
Sorry, okay. So the properties own the freehold?
Yes.
Which are on the Pembroke Place.
Yes.
Thank you.
Yes, Councillor Baxter.
The objectors and Councillor Servant mentioned no consultation, and we need to clarify this because a normal procedure is we should have a proper consultation with any application. If that is the case, this is a big problem. I think if we really have the officers need to answer this question. And you mentioned safety. In what way do you think erecting or having this gate in there will affect the safety of the residents?
So there's two questions there. The first one you want to put to the applicant around consultation.
Yes.
Yeah, because it seems from what the residents or objectors have said, there's no consultation carried out with them. Is that correct?
I'm afraid I don't know the answer. I'm
Okay.
stepping in. I know
Yeah.
that the certificates, the correct certificates are signed, certificate B at the application stage, but yeah, I'm afraid I just not.
Yeah, I appreciate. I was informed that you are stepping in at the last minute
Yeah.
for a colleague who's unwell. So that's unfortunate. I appreciate that, but so we don't have any answer on that one. But it sounds like there was no, from what Jason said, there was no
We
consultation.
will ask the officers later.
Yeah, we can do. And then your second point.
Safety,
Yeah.
yes. In what way your safety is affected?
Well, before, I mean, there was no action before. Now there is a door that opens on to the alleyway, and all along the alleyway are numerous entrance points to our properties, including smaller courtyards, our back doors, and all the rest of it. And seeing as there have already been people seen on the alleyway because we have cameras, we never know who these people are. And so anyone could have very easy access to our back doors, which are occasionally left open. It's kind of a small garden courtyard point for some people's houses, so they might leave them open. So it's extra access to strangers that we don't know.
But if we didn't have gates before and now we have a gate, in what way would that prevent or provoke people to complete this alleyway?
The gate wouldn't prevent anyone. The gate now enables people to have access to an alleyway which they didn't have access to before.
Yeah, thank you.
Councillor Mackover?
Can I pick up to objectors and neighbours just on this point of the alleyway? I did visit it just to understand the relationship and see just how narrow it is. Are you, as residents owning that space, are you under any obligation to keep it open? The metal gate that sort of fronts onto the street.
As far as I know, no. Yeah, we're under no obligation to keep it open.
And equally, with any consent that you might want to apply for on your own land, you could put whatever else you wanted to on your own land.
Yes, and
gates,
there are already
flowers,
bins,
that sort of
plants.
Yeah.
You know, it's not an unobstructed route.
And question to the applicant's agent, understanding that you might not know all the ins and outs. So are you part of a particular firm? I thought.
Fullalong.
Hmm?
Fullalong. Planning consultant. Fullalong.
Full along.
Okay. Good. Different from Lusted Green.
Yeah, I believe they were the architects. We've been asked to speak on this one because we made the second application, but we were asked to speak on this one as well.
Okay. And typically, as a planning consultant, would it be your normal practice to work with your clients and help them consult?
We would always advise to speak to neighbours before an application is made, generally.
And understanding you might not have knowledge of this, but is obviously picking up on concerns that have been expressed. I'm just trying to tie this sort of lack of consultation potentially with the fact that the same thing was applied for last year, but withdrawn, and then it got built anyway. Does that help, you think?
Yeah, I mean,
Does that assist you with a smooth?
we would always
process
advise
of
on
residents?
applications that are not retrospective before an application is made to speak to neighbours. Obviously, it's wasn't done in this case, but
In this particular case, an application was made, just looking at the paperwork, correct me if I'm wrong, and obviously looking at officers as well. The application was then withdrawn, and then your client went ahead and made a structure. I know we are assessing it as we have to, even if it's retrospective, just on the planning elements. But I'm just trying to understand the process because we're obviously in a conflict.
yeah, I mean, look, unfortunately, we weren't involved in the first application. We've come in as I said, we would advise clients to consult neighbours.
But with this application, there was no consultation either.
No, but we came in and it was retrospective, so we came later in the day, so I can't speak for the applicant, unfortunately.
Thank you.
I just had a question on the wall being built. So I appreciate there might be a civil matter around whether they knock down a wall they weren't allowed to, but that sort of goes beyond the bounds of this committee. But if the wall's being rebuilt, won't it be the case that the security element is addressed because there'll be a wall there, and also to a large extent the aesthetic element will be addressed? We won't be able to see the gate.
If we rebuilt the wall completely,
Yes. Yes. Which I mean, it makes a bit of a joke that there's a door there. It's got a wall in front of it, but it does sort of address your concerns. Is your plan to rebuild the wall?
yeah, we would. Yes, we would like to.
So it almost makes the whole sort of door situation kind of irrelevant. It's a wall in front of it. But anyway, just a thought. Any other questions? Yes, Councillor Rossi.
Thank you, Chair, to the objector. So essentially that walkway at the back is only for refuse collection, is that correct?
Yes.
So you have a gate access which you open up, or is it automatically open, or you have a key for that?
No, it's so we leave it open because it was locked many years ago, I think, by agreement between the neighbours, but then it caused problems with refuse collection. So now we leave it open.
So that access is for Pembroke Square residents refuse collection.
Yes, yeah, primarily yes. I mean, it's on the title deeds. The property, the land boundary behind each property is owned by the freeholders, so we can use it for plants or what have you. But yes, primarily it's just bin collection.
So based on your comments in your speech, the door is open just normally. Isn't there
The gate or
the gate? Sorry, apologies. Yeah, gate. Isn't there a track that anyone can walk in? I mean.
Yes, but that was always there. That's not new. That didn't used to be a wall and then a gate was installed. That was something that when we all purchased our properties, we were fully aware of that access point, and that isn't. I think that's even on our title deeds as an easement or something. Whereas there was no access from that point. That was a wall.
So you have sole rights of that land to be modified as anything you wish to. If the
Yeah, in theory, yes. According to title deeds, yes.
I hope you understand that. I know it's a civil matter anyway. I'm doing that's just all right. Thank you.
And just one more question to you, Ms. Priest. Do you know, is the plan to use? Why is this door being built? Is it to use it as a fireplace? What's the reason for the door? Not fireplace. Fire escape.
I understand it's for a rear emergency fire escape.
Okay.
Only.
Right.
Because the existing one didn't meet building reg.
Yeah.
This
Didn't meet building regulations.
Okay. This really doesn't seem, and it might be worth feeding back, doesn't seem well thought through at all, because there's gone ahead and built a door to provide a fire escape on land that isn't owned by the applicant. As not only hasn't there been no permission to use that land from the people who own it, there's not even been consultation with them. So the whole process seems just poorly thought through and poorly executed. But that's just a comment that goes beyond what we're deciding tonight. Any other comments or questions rather before we move to the next session of the meeting? Okay, we now moving to the next stage of the meeting, which is questions to officers. So we can no longer interact at all. So please feel free to take your seats. Thank you. Colleagues, questions to officers? Yes, Councillor Back.
Consultation. We need to know about the consultation.
Thank you for your question. So in terms of the documents submitted with the application in their design access statement, there wasn't any details of any consultation with residents as part of any engagement before the application was submitted. You might have picked from or seen as part of the site history, there has been a number of applications on the site. But as part of this application for the installation of the gate, there wasn't any pre-consultation. As officers, we do often encourage early engagement with residents, and it is part of our statement of community involvement. but unfortunately it isn't a requirement as part of any of the local plan policies. So yeah, it's unfortunate there wasn't any consultation or any discussions with residents on this one.
So it's deeply unfortunate, but not actually a legal necessity. Councillor Retty.
Thanks, Chair. Alice, just checking on the point. So basically, they've withdrawn the rear ground timber gate in the previous application and rebuilt it. Is that not a planning breach?
So I have rechecked. So as part of that application that was withdrawn in 2023, as referenced in section 4.4, the gate as proposed as part of this application was installed as well. So it would have been retrospective at the time of that application. The reason or the requirement for that application to be withdrawn, I believe, was to do with the certificate of ownership, which has obviously been resolved as part of this application.
I have a couple of questions. So first one, excuse me, is around the point made by objectors that that the application wasn't fully honest and transparent in that they said that they were the owner of the land and they weren't. Is that the case? And if so, could that be a reason to reject the application?
So in terms of that reference, there was an application form that was submitted at the date that the application was received by the local planning authority, and that includes what was a certificate A. A certificate B was then sent to all residents and giving them a notice of 21 days, which would then in turn supersede the other certificate of ownership. So officers are of the opinion that all of the statutory requirements of the application have been met and legally is able to be determined.
The fact that the initial application had something which wasn't true on it doesn't actually mean that the revised application, as it were, isn't a legitimate application. And then the second question I had was, could you just clarify for the committee, confirm for the committee that we are in no way, were we to approve this tonight, suggesting that anything to do with its use as a fire escape, and that would be decided by either by another planning committee or by building control? Could you clarify that, please?
Of course. So in terms of its use as a fire escape, that isn't a consideration into what this application didn't require a fire statement, and all members are considering and looking at today is the installation of that timber door and the impact it may have to surrounding townscape and living conditions. If the applicant was to go through building control and they didn't have the correct access over that land to the rear, or they weren't able to open it, then I believe the applicant would need to seek alternative means of escapes in relation to fire safety, fire escape.
Thank you. And my final question is just the other point raised by objectors around security, that by having another access point that could cause a security issue. Is that a relevant consideration for this case?
It is a consideration that members could give weight to, but officers have taken the view that the potential use of that door, should it be used and should there be access granted by the relevant landowners, wouldn't give rise to such harm in relation to security. And we have mentioned obviously this evening that alleyway or the walkway can be accessed from Pepperidge Place at the moment, although there is a gate there which is, I believe, sometimes locked, sometimes unlocked. So yeah, officers don't consider that it would kind of increase any crime or any concerns in relation to security.
Yes, Councillor Bridges.
So, let me understand if the gate is built, but not right now for fire escape. What is the purpose of the gate?
I'm not too sure if the applicant's the gate is installed as we can see in its retrospective. If the applicants don't obtain the correct consents in terms of landlord consent or any consent that may be required after the planning permission may be granted, then it might be that they've got a gate which they can never open, never access and never use. So it would become, I guess, not used at all. But that would kind of be separate to the planning permission in terms of whether they would get consent to use it from the relevant people.
Yeah, but it doesn't make sense.
Councillor McEvan.
Yeah, going back to the question on the application and the certificate A and certificate B corrected. I'm looking at the application site plan with the red line values in our app. I'm wondering if that is actually not correct, because it's implying that the application site includes the passageway that we've been discussing. And that seems odd to me, because we actually said that that is someone else's. That's so, yeah. So would it have been more correct to put a red line around the application of address, which is 42, and then up to where the gate is actually going? I'm just concerned that it's somehow granting some sort of planning permission which is on that full passageway. We're only talking about the gate.
Yeah. So you're correct. So the site location plan identifies the walkway to the rear identified as red. So that all that means is it's the land associated with the development and to facilitate development sought under this application. The neighbouring properties, I don't think the site location plan has been printed in your pack. The neighbouring properties either side are also owned by the applicant and have been identified in the blue line. In terms of the red line outlining all of the walkway, I think it would be as an officer, my understanding that because the door on the plan shows it open outwards onto it, if they want to use that land, they would need to include it in their red line boundary and serve his correct certificates. So I believe that's why it's been included.
Thank you. Any other questions before we proceed to a decision?
Just one more so I can clarify this. Because strictly part of this, as I understand it, is just the material change of a boundary treatment, but we're not, if this is granted consent, are we actually allowing that door to be operated, whether or not? I know there's obviously an informative which says you've got to seek agreement with the landowner to actually use that access.
Yes.
But if we're granting this retrospective application tonight, are we actually granting an outward opening door onto someone else's property? Because if I was, we've had plenty of cases before where someone has asked me to put a gate or a door into a highway. I think seems to be general policy that gate or door must be inward opening to not obstruct other people. If we're granting this tonight, are we actually someone's ability to open that door outwards into someone else's land, even though we're saying that they can't use that land without an agreement?
Yeah. So I'll draw members' attention to the pack in front of you and the proposed rear yard plan. So that shows, you're correct, Councillor McEvan, that the door would open outwards, and you can see where the hinges are on the door as well that would indicate it would go out. So if planning permission was to be granted, it would be granted in accordance with those plans showing the door to be outward opening. But again, that doesn't necessarily mean that they would get the consent or any separate consent from planning permission to actually use that door and open it onto the alleyway.
I'm just wondering if would it be a potential ground for refusal if we say that we don't like the fact that it's opening outwards onto someone's land, and even if they weren't then going to go and use that land, like someone putting a door into my garden that they could swing open, and I would say, well, that's swinging onto my land, but they'll say, well, that being granted because the planning committee sat and saw that it was outward open.
So,
and if it was an application for something different, we'd be considering that. But as an outward opening one,
I think in the case of a neighbour opening into your garden, we would be saying to use that, you would need agreement with you. And if he had agreement with you, then why would there be any reason for the planning applications committee to say that it can't be built just because it opened into your garden if you're in agreement? And so likewise with this, they still need to get all the permission from the landowner to actually open it. But if they don't have that agreement, then they can't open it. But if they do get that agreement, then we need to decide, well, is it an appropriate thing to build? Whereas on the highway, I think there's more of a safety concern, isn't it? If you opened it, you could easily hit someone, which is a bit different.
Yeah.
I mean, but please correct me if.
Yeah, so just on this opening point, if we grant this tonight, even if they don't step on, even if the applicant doesn't step onto the other freehold land, they would still have the right to open and close the door as often as they wanted onto that land, even if they didn't. It's a legal question, I don't really answer. Even if they didn't step onto it, could they flat the door open and close?
No, so it would be my understanding that planning permission may be granted to show the door in its current state in terms of it allowing to be opened onto that walkway. But before the door was to be opened or overhang or project onto that space, they would need to seek the correct ownership or the correct consent from the relative landowners before they could do that. So even though planning permission may be granted, it's kind of the first step in the I guess the relevant consent that they may need to get.
Right. So if this got granted tonight, but without consent from the freeholder of that land to they could not operate that door. They couldn't sort of swing it open and close.
If I could, Chairman, just through you.
Please do.
Planning permission is very separate to land ownership, and I think it's really important we remember that this evening. Now, if you grant planning permission tonight and that door is open multiple times a day, they're not in breach of planning, but they'll be in breach of other laws and rights, and that's still an issue, and that's for the interested parties to seek recourse. I don't know the ins and outs of land ownership law, but essentially you can grant that they're two very separate things for you to see. So yes, if you grant planning permission tonight, you're effectively allowing them to open it out under the planning permission. That means there's no planning breach, but there would be potentially other issues at play that are very separate to planning.
I think that's a helpful summary, and I think we need to make progress now. So wrap that up. Just as sort of very briefly going across the major issues on Townscape. I mean, in reality, this is a back alley. It was the residents who were applying for it, combined with the people on the other side. I don't think we'd really reject that from Townscape issues. So to my mind, there was no Townscape aesthetic issue. In terms of the process, we've been advised that even though errors were made in the original certificate, the process is still valid, and that we can must make a decision assuming that it's a valid application. That's the advice we've received. In terms of a fire escape, I think it's very clear we're not approving this in any way for use as a fire escape. We're just talking about literally what's on the retrospectively approving what's on the photograph there, not its use in any way. And I think maybe the most relevant consideration is security. Personally, I think probably door access where all is now being built in front of it. You have to go through a business. There is a gate access from the other side. Is probably not a major security concern, but colleagues might have a different view on that. I think those are the considerations at play. Right. So I'm just going to do a show of hands. The recommendation. And the final point I'd make is that I think the committee is completely in agreement. It's a deeply unsatisfactory process that has been followed in coming up to the submission of an application, and I think we would all deeply regret the lack of consultation with neighbours. But that being said, we do need to make a decision. So the recommendation is to grant. And can I see all those in favour? All those against? So there's 2 in favour and 3 against. So planning permission is not granted. Could I please have what's the main reason you'd like to put forward, or might be multiple reasons to not grant it?
The main for me is consultation. But even though it's illegal, not legal requirement.
Don't think
is a key.
consultation is strongly encouraged but not legally required. So I don't think that can be given as the primary reason for rejecting. Is there other reasons?
Freehold doesn't belong to them. And even opening the door, there is it poses security issue.
Security
Issues for the-
security issues of
The freeholders, yeah.
additional access to a rear yard in which could cause a security concern to the properties behind them. Okay, would you like to put forward security?
Yeah, can you,
The no-
can you
no
send
rights
this
to
send
use
this
the
my
land.
words? Little bit.
So there's so policy CL2, which looks at design quality, does require development to be secure, so design that plan. So we could refer to that.
Okay.
Yeah, so if it's security of those living nearby,
Yeah.
increased access to
It's a townscape.
something like that. Yeah. What I would say is this is a retrospective application, so something to just bear in mind. It's now open to us to potentially enforce if we think it's expedient to do so. So the committee could just be clear that they're happy to delegate that to officers to consider in taking that conduct. Just because it's already existing, so. And if we think it's causing harm, then we need to really do that harm.
Yeah.
But you're happy to leave
Yeah.
the terms of that.
Happy to delegate that to officers.
So it's
So-
just CL2, I mean, that's all that
Yeah.
could possibly be.
Yeah.
Could we have a proposal?
So councillor Idris, you have
I
to
second.
propose that, and councillor Bakhtiar to second that. And then we need to vote on the reason as well, don't we? So can I see all those in favour of that reason? All those against? Abstentions? That's 3 in favour and 2 abstentions. Okay, so that's the first case on 42 to 52 Earls Court Road. We now move on to the second case on 42 to 52 Earls Court Road.
Thank you, Chairman. So this application relates specifically to the roof structure and the roof at the rear of the site. And so I've just identified with the red arrow the rear projection or rear part of the site, which you can see and you will see as part of some photos as part of this presentation, is currently covered by some scaffolding, which is kind of the white sheeting that you can see on that aerial imaging. So I thought this plan would be quite helpful, and I have received this from the applicant as part of my presentation to members this evening, just to clarify the relocation of the plant. So the application before members this evening just relates to the land identified in the red shading on this plan. There are some plant equipment on the wider site, and you can see that at the bottom here, there's been 2 identified here in this blue shading. But that doesn't form part of this planning application before members this evening. So the application relates to the erection of a protected roof structure and the relocation of some plant equipment at roof level. So this the site has got a complex history as referenced as part of the application, as part of my officer's report, sorry. There has been applications previously considered by the local planning authority for extensions on this elevation that have been refused. One of those applications was retrospective and was also enforced by the council to be removed. So this elevation is the pre-existing elevation, so the elevation that was there before any unlawful works were carried out. And this is the proposed elevation. So I'll draw members' attention to this area here, which is where the relocated plant would be located, and that would be covered by these proposed grills. And then this element here is a extension to that existing roof, and that would be constructed of a black fascia wooden board and would include these 2 vents here. So this is the pre-existing and the proposed elevation, which is known as elevation B. So that's the rear elevation, which is the elevation that fronts on to the rear of the properties along Pembroke Place. And so members can note the additional height here with the wooden board, and then to the back part of that, you can see the timbering, the aluminium enclosure projecting above there. These are some photos of the current roof. So the image on the left-hand side is taken from the end of the roof, kind of looking back towards the application site, and then the image on the right-hand side is taken from the middle of the roof, looking to the rear, and you can see the existing scaffolding covering it. These photos are officer site photos from a property or properties along Pembridge Place. So you can see there is a close relationship between the rear of those properties and the rear of this site. This photo is taken from number 12 Pembridge Place from a bedroom window, and you can see the existing scaffolding which is there. So this photo has been provided by a resident, and I believe also provided as part of your pack in one of the objections. This is a helpful photo to show the state of the roof before the scaffolding was put up. So members can note kind of the existing height and then the form of the roof here with the previous plant equipment located on it. So I thought it may just be helpful just to kind of go through the history slightly. So this is the application that was previously refused and enforced under a 2021 application. So you can see the extension to the roof in this location. And then more recently, last year, there was also another planning application that was refused. And you can see that this is the extension where the proposed relocation of the plant would now be located. And it did also include this kind of lower extension at this part of the roof. That concludes my presentation. I would just draw again members' attention to the addendum report and the additional representation received. Office's recommendation is to grant planning permission subject to the recommended conditions set out within the report. Thank you.
Thank you very much. So I'm actually going to invite all three speakers to come and join us at the same time. So Councillor Siren again, Gautam, Samar, and Claire Priest. Okay, so same as before, Councillor Siren, will you be starting or just Samar?
Yeah, I'm asking.
Okay, give me 1 second. Okay. Samar, you have up to 3 minutes whenever you're ready.
Good evening. Thank you for your time. I am a resident affected by the works. Alongside other residents on properties adjacent to the site, I've been dealing with the noise and enclosure from the site works to which this application pertains. Nuisance that started 4 years ago and persists until today, with very little regard and again no consultation with the residents. As regards this application at hand, I'd like to object on the following grounds. One, the sense of enclosure. So the proposed works, while an improvement on earlier proposals, still adds almost half a meter to the rear roof parapet and is done with materials and structure not fitting for a residential area. Two, the noise and vibration caused. I note the results of the noise report submitted. We do have reservations on some of these measurements given photographic evidence submitted in one of the objections of some of these measurements being taken far away from the actual site. Moreover, the ambient noise measurements that goes into the report captures noise from the vast amount of mechanical and electric equipment already in place as shown in pictures in this presentation. And we contend that if you want to measure the impact on residents coming from the site equipment, you'd have to measure the noise from the site in totality versus ambient noise when all mechanical and electric kit is turned off rather than just the incremental from the piece of kit being discussed. And that brings me to my last point over here. This is a request to add equipment to a site that already has a vast amount of kit in place. Now, I know our count suggests that there's already 20 or more condenser units and 2 major HVAC equipment and fan coil units across the properties owned by the applicant. I note the officer's report that there is no change of use proposed in this application, and there's a claim that the room is used in an ancillary fashion to a Class E building. But clearly, from the pictures in hand, at some point we need to use common sense and question whether such scale of equipment is actually required for ancillary use. Surely what's in place should be enough already. We don't need to be adding more. Sorry. And the last point we make is I'm seeing images of kind of pre-existing kit. It is not our belief that some of that pre-existing kit actually existed prior to 2020. And so it feels like there is some amount of so when we look at that image of pre-existing plant at the back, some of that is indeed actually new and subsequent to any approvals that have been granted, and that I urge some investigation into that. So I hope you can support us in putting an end to this blatant disregard for the neighborhood community by rejecting this and any further attempts to make this a full-scale industrial use site.
Thank you very much. Councillor Siren, you have 2 minutes whenever you're ready.
Thank you, Mr. Chairman, and good evening again. So the proposed roof extension is very close to the back windows of the houses in Pembroke Place. And it's a really tight space, as you can see from the pictures. And the windows of the houses that overlook this site are habitable rooms, bedrooms, and studies. They did enjoy light and space before the scaffolding was put up. And should the extension become permanent, the sense of enclosure would be unacceptable. And this is a compelling reason to refuse planning permission. The extension is being proposed to house industrial levels of servers and cooling plants to keep it functioning. And this is obviously a completely inappropriate use of this space. And of course, we want to support local businesses, and we all want to do that. But this level of equipment is more appropriate to an industrial estate and not the small scale buildings and businesses which define this area of the Old Road, with people living in very close proximity. The second reason I wanted to speak tonight is the noise and disruption this particular building and applicant has caused over the last 4 years. It's a strong recommendation that the applicant consults with neighbours when making an application. This has never happened. The residents of Pembroke Place have been plagued with illegal structures and plants which have made inexcusable levels of noise. They've had to patiently wait for appeals to be refused and enforcement to be undertaken, which to my surprise has also taken months. No one has talked to them, and they regularly wake up to surprises from this site. I would ask this committee to please ask about the background noise, which has been used as a base measure for this noise survey. Does the background noise actually come from illegal plants without planning permission? Has it been measured in the correct place? And has it been measured at night? Because I've been there and I've heard it, and it's really very loud. The last point I wanted to make is that applicants
very quickly.
Well, they use expensive planning consultants and agents to play our system. And as a local council, I feel really strongly that we need to protect our residents who don't often have the resources that the applicants have. But that's not why you should refuse this. You should refuse it because of the sense of enclosure and the inappropriate use of the space.
Thank you very much. And Ms. Priest, you have up to 5 minutes whenever you're ready.
Trailfinders operate a very successful nationwide business on this property and have been located in this part of the borough for over 50 years and employ many local staff, with around 450 staff in Kensington and 80 to 100 operating from this site specifically. They are an important part of the local area. As set out in our submission, the proposals which are the subject of this application have arisen purely out of necessity. The property serves the offices and also the nationwide communications room on the floor below. Communications room in particular must be kept full and be a well ventilated space to ensure that the central server can function optimally. The air handling unit and heat recovery plant enable fresh ventilation in these areas, as well as in the office spaces, which has been particularly important following the outbreak of COVID. The office could not operate without it, and it is therefore essential to the running of the business to keep this equipment in place, protected and in a suitable environment. These units require adequate protection in order to be able to function at the levels necessary. The roof which covers the communications room has had several issues over recent years, and it is becoming increasingly difficult to find an appropriate way to repair it. Given the nature and size of the servers, they cannot be removed and relocated. They also cannot be adequately protected if the roof were to be removed and repaired. As such, the only feasible and practical solution is to provide a protected cover to the roof itself to allow the serving roof below to continue functioning. We understand that it has taken a number of iterations to get to this application, and we can therefore understand the frustration this has caused neighbours and the current disruption associated with the temporary scaffolding in place. However, we now feel strongly that we have a solution which meets the needs of the applicant while also protecting the amenity of neighbours and the character of the conservation area. Following the previous refusal, the applicant spent a considerable amount of time assessing other potential solutions. We put these options forward in a pre-application submission, but the council's advice clearly pointed to the scheme put forward in this application as the most appropriate. It represents a structure with the minimum height possible, which cannot be seen from the ground and which does not block light from neighbours' windows. The officer's report confirms this position and acknowledges the need of the development and also accepts that it does not negatively affect amenity or the conservation area. We would urge the committee to agree and allow this application and support this important local employer.
Thank you very much. Colleagues, questions? Yes, Councillor Bakhtiar.
A question for Mr. Samad. What is the proximity between the proposed development and the nearest building?
I believe it's about 3.2 meters.
3.2.
Yeah.
And you have windows.
From a residence bedroom window to the parapet of the where the construction will begin is 3.2 meters.
So it's about roughly,
Yeah,
Yes, this is.
yeah,
something
Yes.
something that way. Yeah.
Okay.
2.25, somewhere like that. It's in, it's been about that.
Councillor Russell.
Thank you. Just an extension to that question. Your objection is for that additional build that they're proposing and the additional build. Is that what your objection? So are you worried about
the relocation of plant and equipment, just the addition to an already what's now the government industrial site, really, in our opinion.
the relocation? Would it not benefit because there's less site because they're moving on to the other side?
So it is our observation that the pre-existing photo taken over there is pre-existing from earlier works that they had done, but not pre-existing to in the middle of 2020, scaffolding went up over the side. Stayed on for quite a while. We had asked people that were working over there using the alley to go up there what was happening. They said they were doing some roof works to help waterproofing. When the scaffolding came down, it is our opinion, and hopefully this can be confirmed by prior plans, that there was movement of plant that didn't exist prior to when the scaffolding went down. And that picture that we see is subsequent to that scaffolding going up. So when I talk about pre-existing, I talk about prior to the first scaffolding going up in the middle of 2020.
That helps. Alice, could you get that?
So
Which picture?
What
The
we have.
picture, drawing or
This
picture?
one.
Yeah.
Yes.
That one?
So
yeah, well, that one is looking outwards. A picture looking inwards.
That one.
So the scale of that plant up there is not what it was, in our opinion, prior to. And I'd love to look back at what the pre-existing plan suggested it did look like. In our opinion, that is not what the pre-existing was prior to the scaffolding going up middle of 2020.
So you mean there was a construction happening?
There
I
was,
think the suggestion is.
this doesn't look like what it looked like prior.
Yeah.
It should work.
Okay, so the suggestion is, and you'll correct me if I'm wrong, is that additional plant has been added without permission. If we're now approving what's effectively a relocation of plant, we will be approving, in the opinion of the objectors, new plant and legitimising the whole thing.
Yeah, that being
and
across
that's-
was certainly
I
not
think
there.
that's
There's a lot of stuff
one
in
of
over
the-
there that they're suggesting was pre-existing, which is not. In our opinion.
Well, I think it's only fair now to ask the agent, is there is this equipment? Is it purely moving it from one place to another, or is it new equipment which hasn't previously been given permission?
As I mean, obviously, I'm only sort of stepping in here, but as I understand, there was an enforcement notice which had some equipment, I think, and it's might need to confirm this. Which,
We will take
yeah,
up
which
with
was
officers
removed
afterwards as
as
well.
part of that enforcement notice that they complied with. But I believe that's part of this proposal now to relocate that.
Okay, well, we'll take the points up with officers in the next section. The other question I had, I just want to understand, is am I right in saying that the noise producing units on the plans we saw are towards the back? And if that's the case, what exactly is it that's being built towards the front of this picture, i.e. close to the residence, that 46 centimetres of extra height? Is that some sort of piping to get the cold air down, or what is that that's being put there?
So if you've got an elevation.
Yeah, so on the right hand side, what is
So
that?
so as I understand it again, the roof that sits, the actual flat roof is leaking.
Mhm.
So they need, and that's where the server is on that, underneath that. So they need to protect that room to avoid leaking, but they can't lift the equipment because it's quite heavy and it's continuously used serving the nationwide development. So this is the only solution that they can come up with to actually protect it and cover the equipment.
Okay, well, I mean, we're not qualified to say whether you need another 46 centimetres to waterproof a roof or not, but I thought there might be other ways. But anyway, colleagues, other questions? Yes, Councillor Rossi.
Just an action. I mean, in your sense, how do you protect that? Like what? Did you put a beam underneath, or the server is standalone to the structure?
Yeah, I think there's the two elements though, that the roof leaking, the flat roof, so that's serving server, but then also the plant equipment's on top, so it's effectively a dual covering.
Okay, so
So it's covering the plant,
beam.
which needs to be protected and covered, but also it's going to stop the leaking, and they can't replace the roof because they can't take all the equipment off.
Okay. But there's no, on the right hand side of the picture, there's no noise producing equipment in there. All the noise producing equipment's on the left hand side of the picture. Is that correct?
I think Alice wanted to confirm that. I know the noise report covers everything.
Okay, we'll take that up in the next section. Yes, Councillor McDavid.
Just a quick one. It's the same sort of question as we asked in the previous application. There's been a significant amount of time that this application and various other related ones been rumbling on. Did your firm actually advise the client to consult and share plans and share proposals with the residents? And the client said, we're not wanting to.
So we came in at the enforcement stage, so obviously a lot of the work that had already been undertaken. So we were instructed when the enforcement notice was served. So
and that was when,
like
rough, not exact date, but just number of months or years ago.
It was a couple of, I think it was 2022, wasn't it? In January.
So from 2020, just so I understand it, not say it's not obligatory, but from 2022 until 2024, your firm did advise clients to.
We've been working with the council in terms of a pre-application, so we've submitted a pre-application to.
Yeah, but you're working for Trailfinders.
Yes.
Right? And so did you ever say to Trailfinders, it would help if you walk this through?
We said, did you want to discuss it with neighbours? But I think they wanted to sort of get the council to decide which way would be the best way forward, because there were a couple of options at pre-application, so they wanted to understand the council's view
Before consulting residents.
I mean, yeah, I can't really comment on that. That's
Okay. Thank you. Any other questions? We have a few. Yes, call that afterwards. Okay, well, thank you all very much. Now, those are your seats. We move on to the next section of the meeting. Questions to officers. Who would like to start? Councillor Idris.
In the summary, 1.1, the very end, it says two of these refusals were challenged and upheld on appeal. And then the LPA's primary concerns were the impact on the character and appearance of the surrounding landscape and relationship with properties along Pembroke Place at the rear. Has that changed?
Thank you. So as part of the previous applications, the proposed extensions at roof level were significantly larger. So if I draw members' attention back to these drawings, so this is the first application which was built out. So it was built out retrospectively without the benefit of planning permission. It was refused by the local planning authority and enforced. That enforcement notice was appealed. And that enforcement notice was upheld. So that extension and associated equipment then had to be removed from the route. So one of the concerns was the overall kind of scale, bulk, appearance of the proposed extension, and also through the additional heights here, the impact to the properties to the rear along Pembridge Place, namely number 12, I believe. The second application, which was considered, or another application that was considered by the local planning authority, was this application last year. This application was refused. The reason for refusal on this application was the surrounding townscape. So in this instance, it wasn't refused on its relationship with neighbouring properties, but it was refused on its impact to the surrounding townscape and the conservation area.
Okay. So the current application meets those, because if residents feel it's a sense of enclosure, then I think that means the size is still enormous.
So officers have taken the view that the additional height proposed as part of the current application before members this evening wouldn't lead to a loss of a harmful sense of enclosure or a loss of outlet from
So
the rear distance.
there is enclosure, but it's not harmful.
So if we look at and it is difficult because of the scaffolding that's there at the moment, but where the height of the existing rear building is approximately located is where my cursor is. So that is going to be increasing in height by that about 0.5 metres, so half a metre. And so officers have taken the view that there wouldn't be a harmful, as we said, sense of enclosure when viewed from that room. And there wouldn't be kind of a harmful loss of outlet when viewed from that window and the two windows that serve that room. And so officers have taken that opinion. Obviously, that is for members to consider this evening in terms of the impact from that window.
Okay. And also, we were told that the big difference between the two buildings is equivalent to us sitting here and them there. So, what about noise of equipment? What have there been any noise studies, noise measures?
Yeah, so this application has been supported by a noise report that has been reviewed by our environmental health team. One of our environmental health officers have also visited the site and a few properties, I believe, in the previous weeks. So that noise report has been reviewed at length. And in terms of the policies and our noise SPD, the proposed plan as part of this application would comply with the noise criteria. Officers are recommending the additional conditions to further safeguard that and ensure that the plan is installed and when switched on continues to comply with the noise SPD.
So sorry, just 1 second. I just have a follow-up question on that. So the suggestion we heard was that potentially more equipment has been added that might not have permission, and so therefore the baseline against which the noise of the equipment is being measured is sort of an unfair baseline. How confident can we be that that isn't the case? And then also the question is, presumably all the other equipment, even if it is legal, should of course be switched off. So do we require that this noise is measured against, with all that other equipment switched off, and just this machine versus not this machine without all that other equipment being on the back?
Also, isn't.
Sorry, just those two questions first. Yeah.
So in terms of the details submitted as part of the noise report, the assessment for the background noise was carried out over a 24-hour period as required by the SPD. I have reviewed it at length with the Environmental Health Officer, and as part of that report, it is difficult to understand if there is any unlawful plant which has been switched on and operating to calculate that background noise. So I think it's difficult to say in terms of in the noise report that was submitted what plant exactly was switched on to monitor that background noise. All I would confirm to members is that as part of the noise report and that assessment carried out over that period, there wasn't too much of a variation in terms of the background noise that was witnessed or monitored or provided as part of the results for the SPD, as part of the noise report, sorry. So officers and our environmental health officers are satisfied that with the proposed plant, it would be able to achieve the reduction of the 10 decibels required by the SPD, and also would be secured by the condition against the background noise as assessed in that report. So I think as officers, we're fairly comfortable with it in terms of the assessment that's been carried out within the report and how that report has been assessed as well.
And could we in the condition require that on installation, that when a new test is carried out, which I think the condition is already there, but amended, so when the new test is carried out, it should be all other equipment at the site should be turned off during that testing period, so that you can actually measure it against, because we don't know, it seems it's going to be hard to ascertain what's been added and what hasn't been, and has it been there for 4 years, was it covered up, does that therefore invalidate that it's passed, etc. It's going to be very difficult. So could we require that the rest of the equipment's turned off and that provides the baseline, and then we test against that?
So members could look, as you referenced, to either add a part to condition 3 or add a new condition to require potentially a kind of post-completion certificate to show that the plant's been installed and that it complies with the criteria set out within the SPD, the noise SPD. In terms of a condition requiring the testing to be done again with the plant switched off, I think it may be difficult for us to achieve that within the condition. I don't know whether, Lisa, if you've got, in terms of requiring a condition so that they redo the testing with all of the plants switched off.
I mean, if members felt that that would be necessary to isolate it, then we could do like a pre-test before you actually start using the equipment. There's an updated news report. As Alice said, we're fairly comfortable with the findings today, and actually the condition is that, well, we're comfortable enough that the report is sufficient, and that we can put that condition on. As you know, if that condition cannot be met, the plant has to be switched off. It becomes an enforcement matter. But if members wanted that extra comfort, particularly in light of the ongoing situation with different plant, then yes, we can put something on that requires them to submit something to us for review before they actually use it.
Yeah. Well, I
So
think,
condition 3 does refer to all plants as well,
yeah,
not just the new plant.
not just the
Refers
new
to
plant.
everything, so there's a switch off clause for everything in effect,
Okay.
and with an extra condition requiring an extra test. It should be sufficient, but it's up to you, obviously.
Okay, well, I'll have a read of that in 1 second, but I think it's certainly worth considering that additional condition. We'll come back to that at the end. And then, sorry, the other question I had was around sense of enclosure. So it's obviously very close to bedroom window of one of the residential properties. And on the one hand, I sort of understand the argument that 45 centimetres, 46 centimetres, half a metre isn't very much. But it's already, if you were starting at zero, you would say if there was nothing there at all, and then they were building what's there now, you'd probably say, yes, that does have a meaningful impact on sensitive enclosure. So can you just come back with another half metre every time, and each half metre doesn't meaningfully change the sensitive enclosure, but overall, cumulatively, it does.
Yeah, thank you, Chairman. So you're correct. There is a close relationship between the rear of the site and the bedroom windows in the rear of Pembridge Place. I think, as referenced as one of the residents' speeches, it is 3.2 metres, the back-to-back distance in terms of the size. Officers, as I mentioned, have taken the view that the additional 0.4, 0.48 metres in this instance compared to the existing doesn't have a harmful impact. Obviously, if the scheme was to be represented to officers that was adding additional height to that, what if granted and more height, then obviously that would be considered against its own merits, and it may be that any more than that would be harmful. But in terms of the additional height proposed as part of this application, we consider that it wouldn't have a harmful impact in terms of outlook and sensitive exposure.
Thank you. Please, other questions? Councillor Mackett.
I just wanted to pick up on one of the objectors made about the scale of plant that's on the building, and I think they used the phrase that it was ancillary to the use, and yet we are in a very compact residential area and very surrounded. At what point do officers say, because the way that plant is needed for a growing business with global servers and other communications equipment needs to be on all the time, that it becomes more than ancillary and actually becomes a change of use from an office / shop to a technology center of some sort. And if for example, a bit like the cumulative 45 centimeters being added to the height, if 2, 4, 10 condenser units or server coolers were added every year, at what point there must be a point at which but it's considered not just ancillary, but actually the building is changing nature. And maybe looking at it myself, but there did seem to be a large number of units randomly dotted around sides, back areas, facing areas, etc. Are we at that point?
So in terms of the current use of the site, it's as referenced in the officer report, it's used as a commercial building, which is Class E. Class E is flexible in that you can change within Class E without necessarily requiring planning permission. The details part of this application do reference a server room, but that server room is to be used in association with the existing occupier of the building. In terms of the use of the site, when it may be a change of use is when there would be a material change of use in terms of the way that space is being used or the way that it functions. Currently, officers are satisfied that it's being used in the same use class as the existing site, and there isn't a material change of use. So we're satisfied that the use would remain as existing. So I think it would be kind of a judgment call in terms of whether they're ever in the future was to be used any differently that would require planning permission. And it may be that a use which requires more plant could still be within Class E. It would just officers of local planning authority would have to consider that at such time that there had been a change of use.
So just follow up on that. If the whole thing was a data centre, would that still be no change of use because data centres fall in Class C?
So I will have to remind myself of exactly what's in Class E, but usually it does include offices that don't have a harmful impact to residential amenity. I believe it is worded or can be carried out without the detriment to local amenity. So that would kind of be the test. Oh, sorry, Don. I straight.
Also in class B, any industrial process which can be carried out in any residential area without causing detriment to the amenity of the area. So that's also within class E.
Okay,
It's very wide class.
yeah, okay, so the actual activity seems fine, it's just a judgment of whether it causes detriment to the local area, which is what we're discussing in any case surrounding the noise and vibration. That really is the detriment that we're referring to. Okay, colleagues, any other questions? No, I'll just give me one moment and just reviewing, and the colleagues might wish to as well, condition 3 to see if an additional condition could be added on top of that. One second. Okay, I think having read that, I would like to add another condition on top of that, as you described, Lisa, around just making it clear that before it can be used, an additional test would need to be done over a 24-hour period, which would isolate just that machine. So everything else would be turned off, and we'd see against that. That would be the baseline. And does this plant equipment that's been sought permission for here against that baseline break the rules or not?
Yeah, just to check with Alice, with the one that we're isolating, is it readily obvious on the drawings? Can we refer to it when we put it in the condition, just so the applicant is aware? But they are really to isolate.
Yeah, so the drawings provided as part of this application do include the pre-existing roof plan, where there is some existing plant on the roof that would be relocated as part of this application. There is also, as you can see on the elevations, there is also existing plant on the side of the building, which is there at the moment. But what's not captured by this application is that there's also plant within the demise of the wider site, but not necessarily within the red line boundary of this site. So I think we potentially have to reference the plant as shown on the existing plans of this application.
So that means we exclude the plants, the other ones that.
Because
ideally, I'd like to include everything within the property owned by the applicant.
Yeah.
Within the applicant's property.
I think because the red line, the site location in terms of the red line boundary only outlines this centre building. I don't know how we would make it precise in the condition. I'm just going to check the.
Would the measurement be correct? It won't be correct.
Oh no, the site location plan includes 44 to 46 in red, and the neighbouring properties, the neighbouring sites in blue. So it is identified as land also owned by the applicant, if not necessarily forming part of this application site.
What are your thoughts on these?
The plant we're discussing in terms of whether or not it's in scale is 42.
Yes. And there is also plant in 48 as well.
Where is that plant?
Sort of, so is it on the building or in the?
It's in the rear courtyard. If I flip to the photos, actually. So this is the rear of 42, which you can see there's those two units which were shaded blue in the site location plan as being separate. So you've got plant in this location, but then also to the other side, which would be 48, which is this view, there is also plant in this location as well.
I mean, the address of the proposal is 42 to 52, so that does cover for.
Yeah.
Cover it, yeah.
But I think, yeah, I'd like to be more certain which plant exactly are we isolating for the purpose of this test.
But the plant being isolated is plant on that's being applied for on the roof. Whatever number that is, I don't know what number it is.
So you do want the new plant tested.
46. So I think the new plant needs to be isolated as a point. So because if you measure it against the background of lots of other equipment on the applicant's property over, and that's not really a fair background. So it's all applicants' equipment should be turned off, and then the stuff on the roof, and that's the background. Then the stuff on the roof turned on, and does that then break?
I think we can.
Yeah.
I think that's fair if it's within their ownership. So I think we just not the formal words it'd be very long, but we'll make sure it's covered that the applicant is aware. Whether it's we might have to put an informative on to a company to allow us to expand. But it'd be that background noise levels do not include existing plant. And that is switched off.
Yeah.
And then they test the
Okay.
plant. Yeah. So that is that
Yeah,
what we want?
that's what I'm driving at. I mean, colleagues, would you agree? Happy with
That
Yeah.
helps. But I don't know whether it gets us over the line.
No, but we need to put the best conditions on we can, and then
I
those.
agree with that, yeah.
If I may,
Yeah.
I don't believe any condition could address the proximity issue.
Well, that's a separate issue, which is absolutely relevant. But it's just we should always try and put the best conditions on we can, and then vote on it. Doesn't mean that the conditions will be sufficient. But we need to address as much as we can, I think, through conditions first. Any other questions or conditions or comments?
One more comment of whatever the result of the vote, I think I probably want it noted somewhere that we want enforcement to investigate, having heard that there is potentially new equipment that's come within the last 4 years. The age of that equipment or when it was last moved, because that would trigger it. Not benefiting from planning consent. So somehow an enforcement of all newly
Review, an investigation.
Yeah.
Okay.
Regardless of
Yeah. Okay.
Yeah, that's
Yeah.
fine.
Okay. That's noted.
And with regards to this new condition, you're happy to leave it to,
Yes, I think you've got the sort of direction, the general theme of what we want. So very happy to leave it to you to word that.
not just the wording, but the outcome.
And the outcome. Sorry. Okay. Well, I think in which case we proceed to a vote. There's a few issues here. I think again, as with the last case, I'll just make the point that the lack of consultation is certainly regrettable, but is not legally required, and so is not the basis to turn down an application. I think on the then the two or I suppose three main issues are around sense of enclosure, potential impact on the townscape, and noise and vibration. I think on noise and vibration, you know, we've added an additional condition. Beyond that, I personally would be reluctant to say that the noise level is unacceptable, because the evidence we have in front of us is that our environmental health officers have inspected it, says it is acceptable, and that's sort of a question of expertise. We have legitimate questions about, you know, what was the baseline. I think that is addressed through the condition. So in my view, we've addressed the issues of noise and vibration. If it's not acceptable based on the test of that condition, it will never be allowed to be turned on, never be allowed to run, and that's the way the noise is dealt with if it's an unacceptable level. But the idea that it's impossible that it could be at an acceptable level, I don't think it meets that bar. In terms of sense of enclosure, I think that's up for members to decide. It's very close to the applicant's window. So whilst it's only half a metre, it's half a metre of metal on top of the brick, very close to the applicant's window. So there is some impact, I think, on sense of enclosure. Whether it, again, meets the bar of being harmful, will be up to members to decide. And then on usage, very quickly. I mean, Class E is quite broad. I think this falls within Class E. So to my mind, and certainly the advice would be given is this is not a change of use. With that in mind,
just one clarification.
Yes.
When you mentioned townscape, we had a brief discussion about it. The materials of the black metal, black painted timber. I'm thinking that the images, I don't see anything like that. Is that what you were including in townscape in terms of material?
Yeah, sorry, I should have mentioned that. So yes, the black painted timber, and then also the metal of the half a metre extension as well. That is in metal, isn't it? The half a metre.
Yeah, this
The
part
aluminium,
is aluminium.
yeah.
Dark grey colour, and
Yeah.
then this part is the black wooden page. Yeah.
Yeah. Okay. So yeah, I think those are the townscape issues. I mean, it's obviously a better situation than the previous application that was refused, but I think still are townscape considerations. Okay. With that in mind, we proceed to a vote. Can I see all those in favour? All those against? That's unanimous against. So the planning commission is refused. And in terms of reasoning, I'm going to suggest sense of enclosure and townscape impacts.
Sense of enclosure is living condition.
It's a living conditions, yeah. Due to sense of enclosure and townscape impact.
That's to those living at the rear, is it? Is there a particular property, or is it just to neighbouring occupiers along?
I think to neighbouring occupiers, I mean, I think number 11 or 12 is the worst affected, but let's just keep it as a neighbouring, yeah.
And then, sorry, townscape, just what is it in particular?
Well, I think as Councillor Mackover said, it's the new materials, and someone who's facing brick wall as a brick wall, but brick is still a nice material, and now you've got new materials, aluminium, the black painted timber.
Yeah, and I think we've discussed it's the harm to residential amenity and living conditions from both the sense of enclosure and the alterations to the townscape in Congress Reserve.
Okay, so the townscape isn't about the surrounding area, it's still related to living conditions of those people.
Yeah, I think it's
they will see it.
Yeah.
If you're happy to delegate the word into.
Yeah.
Yeah.
Thank you.
So can I have a seconder for that? Well, everyone's having it. Councillor Idris to second. So all those in favour of that reason? It's unanimous. Okay. And that concludes that case. So we now move on to 110 Camden Hill Road. Just pause just for a moment to leave. Let's get through this one.
Yes.
Thank you, Chairman. So before I begin my presentation, I would just draw members' attention to the addendum report. There's an amendment to paragraph 6.22 and also 2 additional representations that have been received, which are included within the addendum report. So the application site relates to number 110 Camden Hill Road, and the property is located to the east of the highway and can be seen identified by the red arrow on the side before you. The property is located within the Kensington Conservation Area, and there is also a Grade 2 listed park or public house located to the north, which is this building with my cursor just here. So the application before members this evening seeks planning permission for a mansard roof extension, which would have dormer windows on the front and on the rear elevation. As referenced as part of the officer report, there has been some site history, including a dismissed appeal, which is referenced as part of 4.6 of the report. So these following slides just show the existing and proposed in elevation. So the existing elevation is on the left-hand side, and then the proposed elevation is on the right. So members can note the proposed mansard extension in this location here, with the proposed 2 dormer windows in the front. This is the existing and then proposed rear elevation. So again, members can note the existing roof form and butterfly roof form there, and then the proposed mansard, which should be located here. Again, members can note the 2 additional dormer windows on the rear. And then this final slide just shows it on section. So you've got the existing section on the left and then the proposed section on the right. So you can see the form of the mansard roof, which would project above the parapet. So officers have considered the application and have found it to be harmful to the surrounding townscape and the conservation area. So the officer's recommendation this evening is to refuse planning permission for the reasons set out within the officer's report. Thank you.
Thank you. We'll be joined by, you've got Mrs. Williams, Mr. Frendo and Mr. Clinch all registered. Right, and will you all be speaking or just one or two?
Just the 2 of us.
Just the 2 of you. Okay, excellent. So you have 3 minutes between you, and please start whenever you're ready.
Thank you. So my name is Alexia Williams and I'm the applicant. We have lived in this house since 2011. My family in the area for over 60 years. We've had family births, marriages, baptisms, funerals across 4 generations in RBKC. We love this area and we want to stay. We're integrated into community life. Our kids attend Fox State School. I was even on the board at St Mary Abbott's Church. But now we're at that point where the 2 children can no longer continue to share a small bedroom. We need to either extend or move house. Our application has received no objections. We have 15 letters of support. That in itself shows our proposal is sympathetic and causes no harm. All letters reiterate that mansards are prevalent in this area. I walked for 5 minutes from my house this morning and counted 42 mansard roofs. Our existing butterfly roof has caused persistent damp problems due to blockages. If we cannot fix this through adding a mansard and gaining the additional bedroom, we will implement the already consented development to replace the butterfly with a flat roof. I'm surprised this granted permission was not referenced in the planning officer's report.
The officer's main objections relate to the loss of the butterfly roof, the alleged loss of the symmetrical V-shaped parapet, and the alleged impact on the terrace. Officers also placed weight on the previous refusal in 2012. Regarding point 1, the removal of the butterfly roof has already been consented. Despite this being a material planning consideration, there is no discussion on this in the committee report. Regarding point 2, it's incorrect to say that 110 and 112 have the symmetrical V parapet. The rear parapet has already been partially broken. The photograph of this is provided in the submitted planning statement. It's all shown on the drawings on the screen as well. Regarding point 3, officers note that the extension would be an isolated roof addition. It wouldn't be isolated as it would adjoin and sit below the existing roof addition at 108 Campden Hill Road. The current proposal is also materially different to the 2012 refusal. The refused scheme included a mansard across both properties. A main concern was the resultant impact on the Grade 2 listed pub, because the mansard above 112 Campden Hill Road would extend upwards on the shared boundary with the pub. This is not an issue with the current application. The other issue was the loss of the butterfly roof. As we have highlighted, the applicant now has consent to remove the butterfly roof, which wasn't the case in 2012. Our summary of the proposals is as follows. The mansard will be sited on a terrace which already varies in height and has a varied roofscape. The removal of the butterfly roof has already been consented. As such, there is no conflict with policy CL8. The mansard is of a traditional design and is subservient and sympathetic to the building. This complies with policy CL2 and CL6. The mansard responds to its context and will preserve the character and appearance of the conservation area. This complies with policy CL1, CL3 and CL11. Finally, it causes no amenity impacts in accordance with policy CL5. Thank you.
Thank you very much. Just under 3 minutes. There are no objectors on this case, so over to questions, colleagues. Councillor Bactia.
Mrs. Williams, you mentioned that you already have consent for a flat roof.
Correct.
Could you expand on that, please?
We gained that at the back end of last year. We applied, we continue to have blockages because of the butterfly. So we have damp issues coming through. And this seemed the natural way to fix that.
Okay, and why you are developing this? You said you have family and your children are growing. Could you tell us more about that, please?
Yeah, we have a girl of 11 and a boy of 9. They're currently sharing a room. They're in bunk beds. We're at that stage now where it's only right to basically gain 3 bedrooms. That's in this property or having to move.
And you've been living there since?
Us as a family since 2011. The kids were born in the house. They've grown up in the house. They go to school 2 routes along from where we live. Their activities, their friends, our life is basically in the Camden Walk.
Thank you.
Any other questions? Councillor Rossi.
Thank you. Ms. Williams, I know you just said you had consent for the butterfly route. I mean, this planning is changing that previous granted consent. Why did you apply for that one before? Is there error in the design or was it?
Yeah,
that you can answer it.
That's probably my fault, because I advised the applicants that I think actually that a mansard would be appropriate in this location, and that would deal with the current issue that they have with the butterfly roof, as well as providing them the additional bedroom that they like. So that was off the back of my advice that they would apply for the mansard.
And you realise that's not correct, and then oh no, so sorry, the current one. Okay.
Yeah.
Okay. So your previous who have done it, the mistake.
Yes, Councillor Idris.
Yeah, so when you, of course, you have some consultation with officers. So when you put them before you proposed to them the mansard, what was their suggestion? They advise you for it or against?
So there's quite a lot of history on this site. So there was a previous application and refusal for a mansard across both properties, so 110 and 112. Now I wasn't involved in that application. Mr. Finch was. I understand that at first officers advised that a mansard approach both properties would be the better approach because it's a coordinated approach. Then obviously that was refused on the basis of the lot of the butterfly roof and the fact that it would extend very close to the listed building, because 112 abuts the listed building. So this is obviously a revised application which deals with the listed building issue because we're not extending close to the pub. And yes, there will be a loss of the butterfly roof, but obviously things have also changed since 2012 because we now have a consent to remove the butterfly roof. That's a new material consideration.
Any other questions? No? Thank you very much. We'll now move to questions to officers. So, yeah. Colleagues, any questions for Officer Councillor Bactia and then Councillor Rossi?
I know what I start with is not a planning issue, but the last census we had declined 90% of the borough residents. And here we have a family, they are trying to accommodate the growth of their children. And we are not trying to break the rules and be against our policies. We are trying to defend it. But this is a rare case, I think. Don't you think we should be lenient sometimes when we have a rare case like this and without coming back to the committee?
So in terms of the assessment set out within the report, there has been harm identified to the conservation area, which is a designated heritage asset. In line with the NPPF, you have to weigh that harm against any potential public benefits of the scheme. In that balancing exercise, officers have considered that there aren't any wider public benefits that would outweigh the harm identified. Officers have therefore taken the view that the proposal is contrary to the development plan policies, and there aren't any material considerations to indicate a decision otherwise than in accordance with the development plan. Obviously, members this evening may take a different view in terms of if there is harm to the surrounding townscape and the conservation area, which there wouldn't require a balancing exercise to be carried out in relation to public benefit. So in terms of the assessment, we've assessed it against the policies of the development plan, giving weight to the requirement of that balancing exercise that's set out in the NPPF, and officers consider that the benefits or the public benefits wouldn't outweigh the harm in this instance.
And is the fact the applicant said that a flat roof has already been consented, so there's already potentially the loss of the historic roof form. Presumably that could be a reason for members to come to a conclusion that there is no harm in this case.
Yeah, so you're correct. There has been a certificate of lawfulness granted for a change to the roof form. I don't believe that has been implemented or carried out, and the roof form, as shown on the existing drawings as part of this application, still retains that butterfly roof form. Members do need to give weight to that certificate and the potential, I guess, fallback position in terms of the certificate of lawfulness. However, I would draw members' attention to policy CL8 in terms of the wider policy, which does also look to resist additional stories on groups of buildings where the existing roof line is unimpaired by extensions. So there is other relevant parts of that policy which officers consider it's contrary to.
Because in this case it's just two properties, and what's included in the group, because obviously the one on the corner does have an extra floor, and then it's only two, so it's not like a long unimpaired terrace.
No, you're correct. So I believe as part of the report and as part of the assessment, it talks about these pair of properties as these two as being the group of the buildings. And you're right, often in other applications and wider terraces, you're considering 4 buildings.
Thank you. Any other questions? No. Well, okay, in which case we proceed to vote. I mean, excuse me, my thoughts are that I think, you probably need at least, if you take all 3 together, the roof line's already impaired. You look at just the 2, it's not really a terrace, or I don't know if 2 can count as a group or not, but certainly if you count 3 as a group, the roof line's impaired. Plus, I think it's well worth giving weight to the fact that consent's already been granted for a flat roof. So maintaining the historic roof forms, given that existing planning permission is, I would say, less relevant here. And so I'm not convinced that there is harm to the townscape. So my thoughts on it. But anyway, we'll proceed to a vote. So just to be clear with the vote, the recommendation is to refuse. So I will ask, I'll do a show of hands, but I'll say the recommendation is to refuse. All those in favour, put your hand up if you're in favour of the refusal. And then if you're against the refusal, i.e. you want to grant planning, then you wait for all those against. Okay, so the recommendation is to refuse. Can I see all those in favour? All those against? So that's four against and 1 in favour. And do we need to vote on reasoning? Okay, so I think I would suggest that because of the reasons I just mentioned, i.e. the roof line already being impaired of 3 houses plus the existing planning permission for the flat roof on that property, means that there isn't harm to the townscape in this application, and therefore we don't need to offset it with public benefits.
If I could just, Chairman, just to clarify, it was an existing planning permission, it's an existing certificate. So it's a little bit different. It's very black and white.
Okay.
And we can't take policies into account. But I just looked for the purposes of minutes, things like that.
Yes.
You can still give weight to it, and you have done.
Yeah. No, that's a fair and useful correction. Yeah, the certificates of lawfulness rather than any existing planning permission. Councillor, back to you. Happy to
propose to approve the application. What do you meant to
Yeah, are you happy to were you putting your hand up to second the
Yes.
reasoning?
Yes.
Okay, so councillor back to your second that. So can I see all those in favour of that reason? All those against? That's 4 in favour, 1 against, so planning permission is granted.
Sorry. Can you, obviously, with regards to conditions, you're having to delegate that to officers to
Yes.
come up with the relevant suite of conditions that are necessary.
Yeah.
Sorry, I just
Sorry.
noted that. But you're happy for that to be.
Happy, delegate that. Shouldn't take a quick break. Yeah, we have 2 cases left. So yeah, a 5-minute break. We'll reconvene at 8:25.
You got the toilet, I mean, you said close. Oh, John, no, I've been in the, you can have a look. Just straight up there on your right. And you go upstairs into the water dispenser, just walk past that. Thanks a lot. No worries.
So we'll reconvene with number 9, Colbeck Mews.
Thank you, Chairman. So this application is in the South Pack, so I'll just draw members' attention to that pack. So there was also some minor changes to the report as picked up within the addendum report as well. I'll just draw members' attention to that for my presentation. So the application site relates to number 9, Colbeck Mews, which can be seen identified by the red arrow on the slide before you. The application presented to members this evening relates to works largely to the rear of the site in the form of a first and second floor rear extension. It is worth noting, and as noted as part of the report, there is some history on the site, which I will also draw members' attention to as we go through. So this is the existing elevation. So you've got the existing front elevation on the left-hand side and then the existing rear elevation on the right. So there was a previous application that was considered by the local planning authority and that was granted, and that granted planning permission for some alterations to the windows and the openings on the front elevation, but also the proposed extension and the addition of this terrace at second floor level, which members can see here. So that has been granted, but it hasn't yet been erected so far. And then following that planning application, there was an application considered and consented from the local planning authority for a certificate of lawfulness. And that also related to some changes to the openings and to the front elevation and the enlargement of an opening at the rear of the property, which members can see here. So the proposal as part of this application largely seeks to combine the application that was granted through planning permission and the application that was consented through the lawful development certificate. And so members can note the enlarged windows on the front elevation here and at ground floor level, and the replacement of these garage doors. On the rear elevation, the change does result in a slightly larger opening on this rear elevation, which can be seen here. The terrace would be in the same location, and the form of the extension would be the same as previously granted. And then this just goes through kind of the existing and proposed section. So these are the existing sections. Then this is the proposed section. So members can note the first and second floor rear extension, and then kind of the proposed terrace in this location just here. And then these are some site photographs. So these are taken from the rear of the application building itself, looking outwards of those rear openings towards the rear of the site. That concludes my presentation. Officer's recommendation is to grant planning permission subject to the recommended conditions set out within the report. Thank you.
Thank you very much. I'll be joined by Mr. Du. Apologies for the pronunciation. Beyond.
Yes.
Yes. Please come and join us. And Mr. Watson is the agent. Thank you. Mr. De Bion, you have 3 minutes whenever you're ready.
Thank you. It first, as described by it's a first public consultation for planning application for a basement construction and changes to both front and rear elevations took place in January 23. Front elevation in Colbeck Mews in particular, were the subject of some objections, but after some modifications were approved in May 23. In December 23, a second public consultation seeking a further planning permission, cancelling the basement and proposing alterations to both the front and rear elevations, including, and I quote, removal of garage door, replacement and realignment of doors and windows, and insertion of roof lights to front and rear. A total of 4 objections were lodged, including against further major alterations to the front elevation compared to the initial planning permission. The planner's report, dated late May 24, makes a passing reference to another planning permission CL 230678, which had apparently been granted on the 11th of December. This concerns the front elevation and allows major design changes compared to the planning permission granted in May 23, thus rendering our current objections null and void. It is only after lengthy online research that we, local residents, discovered the existence of this other planning permission. As far as we are aware, the December 23 Planning Permission reference CL 230678 did not follow a process involving public consultation at the time. Our questions are, how can such material changes to the front elevation go through a planning permission process that did not involve a public consultation, as they clearly break the harmony of the design of the group of 8 houses to the west end of Colbert Mews? Should you confirm that this is a due process, we want to express our views that this type of application for material changes after an approval feels like an improper way for the applicants to avoid public scrutiny, and comments from residents and lead to a dysfunctional and unfair planning application process. In any event, shouldn't this current application have made it clear that part of the changes compared to the first application and approval had been improving into it? This would have prevented us and other neighbours to waste our time and this committee's time thinking that our legitimate comments would be listened to. As local residents and lay people, this process appears to be a travesty of a so-called public consultation process at best. So we feel strongly that we've been misled. Why waste both council officers and local residents' time and effort with a partial and or misleading public consultation? This appears to be a waste of taxpayers' money, hence this strong objection.
Thank you. And Mr. Watson, you also have up to 3 minutes whenever you're ready.
Thank you, members and officers. So as you've heard, the application includes 3 main elements. There are fenestration alterations, a rear first floor extension, small second floor cat side roof extension, and finally a rear balcony or terrace as it's called. As has been summarised in your officer's report and in the presentation, excuse me, most of the works have already been approved under previous permissions and allotted on consent. So firstly, the planning permission was granted for the extensions, the dormer and the balcony. And secondly, more recently, a lawful land certificate issued to confirm that the fenestration changes would comprise permitted development, so didn't require planning permission. I believe that's what the previous speaker was talking about. Permission was also granted for a new basement floor beneath the building as well. However, since gaining these previous consents, the owner has reviewed the scheme and has decided not to proceed with the basement, which was one change, and is now also seeking a minor change to the rear doors, which open out onto the approved balcony, which again, I think the officer said is about 70 centimetres wider. So really, for absolute clarity, what this application is effectively seeking to do is to amend the previous schemes, removing a basement, widening the doors, and there are some minor changes to the alignment of the windows on the front just to make them follow through more correctly. The extension of the doors would be 70 centimetres wider than approved. We agree with the officers that this minor change wouldn't affect the character of the building or the conservation area. The size of and design of the balcony remains exactly as approved, and the small change in the access doors clearly wouldn't affect the way it was used or how it relates to neighbours. The changes to the front facade windows are very minor and barely perceptible, but they do just line the middle set of windows, dormers above, and slightly offset in the approved scheme. In brief conclusion, in design terms and relationship with neighbours, we would suggest that the application doesn't change the impact of the proposals on the neighbours in any way compared to the approved scheme. There is obviously a material benefit that the basement's no longer going forward. Also, there'll be a much lesser construction programme. We estimate about 6 months quicker than it would have been. And so really, we just hope the members are able to support the officer's recommendation and let the changes go forward. Thank you very much.
Thank you. So I'll ask the first question to the objector. So I take your points about the regarding the change to the facade, which we've been told was approved either, and I'll come to that in a moment, but either under a planning permission or under a certificate of lawful development. And your frustrations with that process, and I hear all that. That aside, is that really what your objections are about, or in terms of the minor change to the rear of the property and the increase in the size of the windows? Are you concerned about that at all? Or is it
All
really
objections were based on the drawing supplied, which was the initial planning permission granted, and the new one.
Yeah.
And the original granted permission showed windows in terms of height on the first floor exactly the same as the neighboring properties.
Mhm.
And on the ground floor, it maintained I think one garage door to be replaced by a door from say 70 meters or so upwards. Again, exactly similar to the one to the, I think, number 8 to the right. And it provided a front door with a window above it, exactly in keeping with all the other properties. And then the garage door to the left of that property. So at the time, you know, we felt that all of a sudden, so that was granted. We thought it was decent proposal. Then all of a sudden we're shown first floor windows from floor to ceiling, which is totally alien to the rest of that part of the muse. And the ground floor, all of a sudden, it's from what we can see, glazed windows from floor to ceiling on one side, a solid door all the way to the ceiling, and then the garage door. And all of a sudden, it looks incongruous that you would have one property totally different to the others. We are in the conservation area. We constantly read about, you know, and the concerns of both the planning authorities and, you know, residents to try and keep, especially the muse thing. I know there's a lot about, you know, making sure the arches are kept, everything to keep that special character of that part of London.
Yeah, understood. So could we bring up the picture of the front? So just going back to the applicant, the agent for the applicant. So yeah, so these 3 windows across the front. I mean, to agree with what's just been said. I mean, I walked down there a couple of days ago to have a look at it, and he's absolutely right. All the other properties around have sort of 2 windows, and then this kind of long, yeah, exactly that. And presumably it's to do with the historic use of that muse, and you know, if you throw hay bales over it or whatever it was, but they're all the same. So the change of that fenestration, so that first floor fenestration, you're saying that was approved by planning permission or by a certificate?
That's the certificate of law.
Okay, so it was said. So you said to the council, we don't think we need planning permission to do this. Can you confirm that?
That's right.
And they came back and said, yes, you're right. You don't need planning permission. So we can ask officers about that in the next phase. But okay. It is. To me, it seems very unfortunate for the heritage of the area. But I appreciate, you know, if you have a certificate of lawful development, then that is highly relevant to tonight's proceedings. Colleagues, other questions? No. So we'll move on to questions for officers. So in regard to that, the fact that it's, I mean, I don't want to relitigate a point that's been decided, but it does seem strange that in a conservation area, something which is so crucial to the look and feel of that Muse Street and its historic use could be approved, could be told that actually you don't need planning permission to do that. Can you tell us why?
Of course. So the certificate of lawfulness that was granted was considered against the permitted development regulations, so specifically under Class A, Part 2 Class A. And as part of that, there's conditions. So those conditions require the materials to be of a similar appearance to what's in the existing building. As part of the officer's assessment, it was considered that the timber, the proposed timber windows or the alterations to the windows were of a similar appearance to those used on the existing dwelling house, and therefore was permitted development under that relevant class of the Act.
Because normally, so I mean, materials are important, but normally, especially in the conservation area, we're so careful about what windows look like. And here, I mean, we can't see the other properties on there, but I've been down there and they are all the same. And none of them look like what's being proposed. They all look like what's existing at the moment. And okay, maintaining the same materials is good, obviously, but surely that's a change to the heritage and the look and feel of the street.
So it may be a change to the appearance of the building, but it wasn't considered or as considered under the certificate. It wasn't development requiring planning permission and therefore was consented as lawful as permitted.
And is that why neighbours weren't informed, because it technically wasn't a planning permission?
So yeah, so the application for the certificate of lawfulness would have been advertised as part of the weekly list in the local gazette, but in line with our statement of community involvement, there wouldn't have been direct letters to the adjoining properties, and there wouldn't have been a site notice.
Okay, so unless you are a regular reader of the gazette, you wouldn't have known about it. Okay, well that probably perhaps not satisfactory, but at least explains why neighbours weren't informed. Is there, now that certificate of lawful development has been issued, is there any recourse, or is that it?
So members, that has been consented. Members do need to give weight to that consent in terms of there is a consent to change the windows, and the local planning authority have made a decision that those works could be carried out without even requiring planning permission. So they could be carried out without an application being submitted to officers to consider anyway.
Okay, but is it another, can we still refuse planning permission for that? Say we don't believe it meets staff plan permission, even though it has a certificate of lawful development, or actually once it's got the certificate?
I think it would be fairly difficult to form a reason for refusal on that. Members are taking a judgment as to whether the proposal as a whole continues to preserve or enhance the surrounding townscape and the conservation area. So it is a consideration in terms of the new openings and the alterations to the rear of the property. But I think members do need to give weight to the certificate and what could be carried out without the need of requiring planning permission.
Because what I don't want to do is, if there is any sort of recourse that neighbours could take regarding certificates, which is available to them, to then take that away by also granting planning permission. Is there any recourse?
Do you mean any kind of form of legal?
Yeah, exactly.
So I think in terms of the date that the certificate was granted, I think it would have passed in terms of what could be judicially reviewed. So I don't believe there would be any kind of legal route for potential residents to take in terms of challenging that decision. I don't know whether you want to.
It is well past that date. Yeah, I think the issue here is that the windows, the replacement windows and doors have been assessed against the permitted development order and have been found against that not to require planning permission. So if it doesn't require planning permission, then it's very difficult. How could you redress that? How could you revoke a certificate which says it's permitted development when it is permitted development?
Yeah.
I suppose.
I mean, how can you
I'm not saying
use this application on that basis if it's permitted development?
Well, because if there is an avenue open, and perhaps it's not, for residents to challenge that decision and say we think the decision that said it doesn't require planning is incorrect and it does require planning.
That passage of time.
That passage of time.
I mean, they would have to get their own legal advice on that.
Because you see what I'm saying, if that was open and they won that and says yes, it does require planning, then, and we had just given them planning, then it would make the whole exercise pointless. But if that
it has passed,
recourse
6
is
weeks
okay.
of this decision, so certificates are only lawful at the point at which they are submitted. So it doesn't run and run and run. It could be that in 6 months' time it suddenly becomes unlawful if the order was to change. So it is only lawful at the point at which the application is made. The decision has, as I said, has been made, and it can't be legally challenged through the judicial review.
Okay. So given that, is there any, so there's a certificate of lawfulness that says it doesn't require planning. And now we're being asked for planning, okay, not just for this, for other things as well, but this is one of the things we're being asked to give planning permission for.
Yeah.
Can we say, is it legitimate to say, no, we don't believe it should get planning? Because it's strange, because we've been told it doesn't require planning, but now we're being asked to give it planning.
Well, I mean, I'm assuming it's because when the development is built, it's going to be built as one operation. I imagine the applicant is looking to capture all of that in one. That's not uncommon. A bit like the case before where they had a certificate, you know, it is for you as a decision maker to give that weight, and what weight you give that is up to you. And it's part of that kind of decision, as part of the weight that you attribute to it, is how realistic is it that they will implement that well. It sounds fairly realistic to me that they will just change. So with windows, so you know, chance of that coming forward in its own right probably quite high. Now, under planning applications, you are looking at planning policy, and you may well take a different view that these changes actually do not accord with particular policies in the development plan, and there are no other material considerations that would indicate a different decision. What you're essentially doing, if you go down that path, you're saying the way that you give to the certificate is actually limited, because that would be the other material consideration. But that is for you. You know, my advice to you would be that the certificate does carry significant weight. It cannot be legally challenged. It is part of this proposal, but you are looking at kind of individual, you know, all aspects. You can refuse on one part, but I think the ability to do it on windows or fenestration is quite limited.
I mean, I also appreciate it wouldn't achieve anything, because if we didn't give permission for the windows, it could still be built based on a certificate of lawful development. Is there any way of carving out those three? Because the rest all looks fine. Is there any way of carving out and giving planning permission for the rest, not giving planning for that, even though they might be built, but probably will be built anyway?
Yeah, I mean, we sometimes use conditions where you say notwithstanding what's shown in the approval, permission isn't granted for that. We don't tend to carve it out when it's clearly part of the description. It's normally if somebody has missed off the description and we want to clarify the scope of the permission that we're given to align with what the applicant is.
I mean, there are a number of things in the description. Alterations comprising rear first floor, fine, part second floor with roof lights, that's fine. Balcony at second floor, that's fine. Enhancements to front fenestration, including removal of redundant garage door, the garage door is fine. Replacement and realignment of doors and windows, and insertions of roof lights. So it's just one small part of the description.
I mean, is the concern about the design size? Because what you could consider doing, although as we've already said, the certificate exists, so it's probably not going to get you what you want, but you could add a condition that says, notwithstanding what's shown on the drawings, further details of that fenestration must be submitted. But I think we need to be quite clear about what you would be looking for that's different to that, and then bear in mind that with the certificate they can do that. So,
but yeah, I mean, what
we'd
be looking for is basically to keep, design-wise, keep it how it is now. If they wanted to make it glazed, whatever, that's fine. But the design, because it's so uniform down that new street. If you go back to the previous, yes, they all look like that. So yeah, so that would be what we're looking for that, and then
probably outside of the realms of condition in terms of reason.
Can I just to comment? It probably goes along with what you're saying. If this was coming to us as a planning application, and notwithstanding, because we actually have objections, we've had feedback from neighbours about this. If this was coming as a standalone application, I would be looking to refuse it on the basis of the harm was to the community and terrace. And because it is an application, I can refuse it for that. And then, you know, if the applicant had come up with something which wasn't referring to those things, then those other elements, would be acceptable. But I'd be upset if I was walking past that in the future and I sat there and gave that permission, because that always And that was great, I think, but it isn't in accordance with local development policy. And if anyone else was to ask for permission, we would be saying no to it.
Exactly.
If 2, 3 or 4 others individually were asked for that, we'd say no. And in all of these, it's like we all live very close to, if not it, we live very close to these sorts of painting style muses. This is something we're aware of.
Yeah. So, okay, notwithstanding the certificate of lawful development, if we're happy with everything else, the changes to the rear, the changes to the ground floor, but not happy with the changes to first floor, would your advice be that we should reject it?
If you've identified that there's harm in relation to planning consistent development plan that isn't outweighed by other considerations, and that does include the certificates, I think you need to be very clear.
Yeah.
You're not disregarding it, you're
Yeah.
simply giving it limited weight. And that the harm is not outweighed by.
Yeah.
And is it the first floor and the second floor that's changed as a result?
So the ground floor has changed as well. It didn't seem to be such an issue, but I mean, the first floor is the main.
It's the most unusual for the size and changing in style. Is there a picture of the existing, which would show the second floor?
Yeah.
I haven't got a photograph of the front, I'm afraid, but we've got the existing elevation.
So there are 3 existing elevations. There are 3, so that's not significant.
So there are 3 windows at first level at the moment, and then as granted as part of the planning application that was considered with the basement, that central window was changed.
So that has actually benefited from.
So that has.
So we've lost the hay loading.
Yeah. So that has planning permission, which again could be, although the basement isn't going to be applied for, the remainder of it potentially could be implemented.
Very difficult.
And then the certificate is when all of the windows were enlarged at first floor level and there was alterations at ground floor. The other thing to potentially note is that from the change at first floor from this certificate would realign the windows at first floor better with the dormer windows. And so if you see on the certificate that was granted, they were kind of offset slightly. And a change would be that they would be aligned with the dormers above.
All of that is absolutely fine and sensible, but it's just
Well, there's a question then. Given that, is there any way that the details to be submitted, could we look to try and reduce the floor to ceiling height of the first floor windows, or is that going to be impossible to achieve through
going back to what's been granted?
I mean, you can. I think that the condition just needs to be sufficiently precise so the applicant is aware of what they may need to do to satisfy it, so you don't end up with a condition that's never discharged. Because we can never reach an agreed position. So I think, you can do, and notwithstanding the further details are required, and the opening should be reduced to better reflect the existing openings or something like that. And we can put an informative answer supplement that to make it clear, but.
I think it would be about taking the sills back to the same level as the neighbouring properties.
I think with where I'd be.
And the agents in the room see know anyway, but it is open to the applicant to either go down that road or they can appeal that condition and ask that it, or apply for its removal, which I'm sure would then come to this committee for consideration. Because they do have the certificate in place, but I appreciate the tension planning application.
And just to be clear, the central sort of door window, whatever the term is, as exists now, that's planning permission for that to be removed has already been granted.
It's really small.
Yeah, correct. So you can see that in that 2023 planning permission, there was some alterations in terms of ground floor level, the reconfiguration of the front door, and then also the alteration to that window and to aids in the sash.
Yeah, it's such a shame because it's rare that you get a street where it's all suddenly the top half of the street, which is of that design, the bottom half is totally different, but all the top half is uniform at the first floor, and it's a real shame to lose that, but I guess it's already been lost, at least in terms of planning permissions granted. Okay, well, I think we've put on sorry, I'm really sorry, I would love to, but we can't. So I think the best we can do is put on a condition requiring the sills to finish at the same height as the neighbouring
Details.
properties. Details.
I think these actually,
Yeah.
it just allows the
Yeah.
actual opportunity to
Yeah,
get right.
Is that the first floor?
yeah,
For the first floor, yeah.
and the rest is fine. I mean, the ground floor is different properties have slightly different designs, but it's the first floor which it protects. And maybe the applicant will reconsider his first floor designs and decide that might want to keep what's currently done. Okay. Is that clear then? Yeah. Right. In which case,
Can I just check?
Yeah.
Chairman? Sorry, this new condition about details to be submitted.
Yeah.
Happy to obviously leave it with officers, not coming back.
Yes.
Yeah.
happy to leave it with officers, but the guidance we're giving is
Yeah.
that those sills would be brought up to the height of neighbouring property. To all three of them, or just at least the two side ones?
All three.
Because the middle one,
It's
in
got
neighbouring
windows, yeah.
properties, they have a door. I suppose maybe the least harm is all three. So,
Yeah. Yeah,
Okay, cool.
unless they decide to,
because that's what's there currently.
yeah,
So
but
you could have an argument that it might be better for the middle one to be lower. I don't know.
But
But
the width is.
Yeah,
The width
it's
is
very
different,
different.
yeah.
Okay, so
So still height would be.
all three to come up to the height of the sills
yeah.
of neighbouring properties. Right, in which case, everyone happy with what we're voting on? So recommendation is to grant. Let's see, all those in favour? And let's say unanimous in favour. Thank you joining us for that case.
We voted on a condition.
We don't need to vote on it. We don't need to vote on it. So the final case is 12 Albury Road.
Thank you, Chairman. So this application is back on the North Pack in terms of the report. There's a slight amendment as picked up as part of the addendum report to paragraph 6.4. And I would just further update that where it says contact, it should say context in that paragraph. And there was also one additional representation received as well. So the application side relates to number 12 Albury Road, it's a property located within the Kensington Conservation Area. You can see it identified with the red arrow on the slide before you. This application relates to the addition of balustrading at roof level to create a roof terrace and the associated alterations, which include an access hatch. I thought this plan was quite helpful, and it shows the existing properties identified in the red colouring where there's existing roof terraces and orange for the red. So that shows you the application site identified by the red outline and the other properties within the immediate vicinity that have roof terraces. So the officer recommendation is to grant planning permission subject to the recommended conditions. That concludes my presentation, but happy to answer any questions.
Thank you. We don't have any speakers on this case, I don't think. No? So colleagues, questions?
What is, sorry,
Yeah, sorry, go ahead.
my question is, what is the rule on overlooking existing property?
So policy CL5 of the local plan seeks to obviously maintain an acceptable relationship with neighbouring properties. The distance from the back of the property to the back of the properties on Kensington Square is around 14.5 metres. The terrace has also been set in slightly to the rear, and I think the drawing should be in the pack.
Yeah.
So if you look at the roof layout, the roof terrace would also have a arrangement where it's set in further to mitigate any potential impact to the property to the east of the site. So officers consider that the separation distance would be acceptable, and there wouldn't be a detrimental impact in terms of overlooking or loss of privacy.
So there's no new views that don't already exist from windows or?
Yeah, so the property benefits from openings at the front and the rear elevation at those upper levels as well. So there would probably be similar views that's already achieved.
Yeah. Okay. Yeah, go ahead.
Yeah, sorry. So, just checking on the overlooking part.
Yeah.
Do you roughly have a measurement from the roof terrace to the neighbouring property? I mean, all the objections, roughly.
So I'll just double check where the residents objected from. The distance from the back of the rear of the property, so where the roof terrace would be, to the back of the property on Camden Square is around 14 metres. 1-4. Yeah, sorry. Yeah. And I believe that's where the prime concerns that were raised from residents were from Camden Hill Square.
So essentially, the garden of the current property would be at least 10 minutes. All over the road could be.
So yeah, so there would be views from the roof terrace towards the rear, and there would be views towards the rear garden of the adjoining properties, the property itself, and also the properties along Camden Hill Square. So there would be new views. It's just that officers have taken the position that those new views would continue, I would say, to maintain an acceptable relationship. But as kind of considered, the other applications members can consider that and may come to a different view. But given the site layout, the kind of relationship with properties, they would be roof terrace.
So based on the building structure, I'm sure there would be windows top floor which would have the same view.
So yeah, so in your pack there is the all of the elevations. So you can see that the alterations only relate to roof level. So they only relate to those alterations to the metal railings and the access hatch. So on the rear elevation, there are openings at ground floor ground, and then you can also see at second floor level, there's 2 openings kind of in the more central part of the building, which make cursor here, and there's also kind of a high level opening on this part, the rear elevation there. And members can see that in section detail as well. So the smaller opening does look like from the section is above head height, but the lower down openings on the rear, I presume, or I would consider that there would be views out towards the rear. You can see that on section BB.
Any other questions? Yes, Councillor Baxter.
Looking at this photo, it looks like the neighbor, next door neighbor, they have a terrace already.
Which photo?
Yes.
Yeah,
It's 2 doors
Am I
up.
right?
So that this photo with the arrow.
Yes.
Yeah. So I believe that photo's been submitted from an objector. So that's taken from Camden Hill Square, looking onto the application site. So where the yellow arrow
But
is.
this is a terrace, isn't it? Look at the
So
terrace.
yeah, so that is a terrace at which looks like a terrace at a lower level, but obviously not a terrace at roof level. Yeah.
Oh, that this.
Yeah.
You had, I think, you have a map, don't you, with the property? So the orange ones, the ones that have terraces already
At roof level.
at roof level.
Okay.
Yeah. Okay. All right. Yeah. Any other questions? No. Okay. In which case we see to a decision. Recommendation is to grant planning. I see all those in favour. And that's unanimous. So planning permission is granted, and that brings an end to tonight's proceedings. Thank you all very much.
Thank you.
Yeah. Yeah.
It kind of got to mine.
Yeah.